Seated.
Thank you.
All right. State.
Yes, Your Honor. Is the court's ready?
I am ready.
All right, Your Honor. In this case, I'll go through each of the bases for, or the requested bases for commitment in order, starting with the felony dismissal. Standard of proof here is clear, cogent, convincing evidence. That means that the facts in issue need to be highly probable. The standard for intimidating a judge, or the legal standard for intimidating a judge, is that the person intimidates a judge because of a ruling or decision the judge made in any official proceeding. And threat means under RCW 9A04110 sub 28 to communicate directly or indirectly the intent to cause bodily injury in the future to the person threatened or to any other person. And of course, as the court's aware, in these cases, the state is not required to prove intent. In this case, the main issue I'd like to get out of the way first is whether Mr. Donahoe was actually identified as the person making the threat here. That's based on the testimony mainly of Detective Reynolds. Detective Reynolds conducted the investigation. He had the letter. He went and spoke to the person who apparently had addressed the letter and determined that that person did not write the letter by comparing the handwriting on the letter to the envelope. He then had corrections deputies seize some documents from Mr. Donahoe's cell. He saw that it was Mr. Donahoe's cell and saw the deputies go directly into and out of his cell with this bag of papers. These included some handwritten notes that the deputy compared to the letter in issue. He compared the way the R's were written and found that those looked similar. He looked at the word family in both documents and said that those were similar, said both were written in uppercase. And during court, while Detective Reynolds was reading from the documents, Mr. Donahoe was correcting him on some of the language in the documents. One of those notes from his cell also contains a cause number, which was 19100427434, which is a cause number from Mr. Donahoe's competency evaluation, further connecting him with those writings that were found in his cell. So, based on both the handwriting comparison and those similarities in the exact match between those cause numbers, it's highly probable that that Mr. Donahoe was the person who wrote that letter based on the contents of that letter, the contents of the notes, and the other indicia of reliability here. Next, the statute requires that the person direct that threat towards the judge. And under State v. Hansen, which seems to be the leading case in this area, decided in 1993 by our Supreme Court, the citation is 122 Wash 2nd 712. The court looked at what it means to direct a threat to a judge, and I'm just going to read directly from the court's opinion there. A threat can thus be defined as communication made directly or indirectly with the intent immediately to use force against any person or to cause bodily injury in the future to the threatened person or any other person. This language evidences a clear intent by the legislature that this statute include threats communicated in an indirect fashion as well as direct threats. Under this interpretation, whoever threatens a judge either directly or indirectly, for example, through a third person, because an official ruling or decision by that particular judge is chargeable under the statute. The threat may ultimately find its way to the judge, but that is irrelevant with regards to the commission of the crime. So the fact that Mr. Donahoe did not address the envelope to Judge Lanise is irrelevant. The fact that he named three different judicial officers in the letter is enough to meet that element of the statute. He directed a threat, an indirect threat, to Judge Price, Judge Lanise, and Commissioner Corticray. And then the next element that we're required to prove is that conduct was because of a ruling that the judicial officer made. And Judge Lanise testified that the only way he knows Mr. Donahoe is through these legal proceedings. He knew him through that civil action he entered, or that he filed, and because of an arraignment in another criminal case. It would strain the bounds of reason to say that this threat was because of some other reason, based on the fact that Judge Lanise only knows Mr. Donahoe through these legal proceedings. And then finally, outside of the statute, the state's required to prove that this was actually a true threat, that it wasn't made in jest, and that it was a threat of future harm. That's to avoid any First Amendment concerns, people simply stating their minds. Defense counsel alerted me beforehand that she would likely be citing a case, State v. Brown, where the defendant spoke to another person about previous thoughts of harming a judge that were in the past. And that's distinguishable from what happened here. Mr. Donahoe wrote in his letter that he's making a motion to kill in 24 hours, and later said, I have a right to ask a judge to allow me to kill you without due process. And then also looped in family, wife, and kids into that. That is a threat of future harm, and even though Mr. Donahoe couched it in this kind of legal language that he's asking a judge to kill these people, is irrelevant. To add this extra language and then say, oh, well, then it's not a true threat because he added this extra verbiage that gave it this veneer of some kind of process that he was going through.
It's called due process.
Is besides the point. He was trying, he met the elements of the statute here by directing this threat of death towards these judges. And that's what the statute is intended to speak to, is somebody who's making these types of threats to judges.
You can't override a federal law with a state law, and you can't have a person I've never seen before testify, you lie so much, you don't know you're incompetent, but I'm sure you do.
You need to be quiet, sir, please.
The statute is meant to protect against these types of threats that are made because of judges making decisions in official proceedings. Additionally, there's extra evidence here that Judge Lanise took this as a true threat. He said that he was concerned about it, that he took safety precautions, he talked to a victim's advocate, and he alerted his family to the issue and even showed them a photograph of Mr. Donahoe. So on that basis, on the basis of the high probability that that the letter, which was not signed, was sufficiently connected by highly probable evidence to papers that were taken directly from Mr. Donahoe's cell, coupled with Mr. Donahoe's continuing statements
We're here to
that
discuss
corroborate.
whether I'm non-functional, not the issues that need to be decided in a criminal court.
You need to be quiet.
Am I gravely disabled or not? That's what you need to focus on. Then
All right,
send me
sir,
back to the criminal case.
I'm not going to ask you one more time to please be quiet. If you have one more outburst, I'm going to have no option but to have security remove you from the courtroom for the rest of the proceedings. Thank you.
The fact that the threat was that he communicated a threat, though indirectly, to Judge Lanise and the other judicial officers, that it was likely because of a decision that Judge Lanise rendered. There's also additional evidence in the record that in the pleadings that Mr. Donahoe filed, that Judge Lamise dismissed, that Mr. Donahoe was displeased with Commissioner Corticray about his decisions in that case, and that he felt Commissioner Corticray had violated due process. And finally, there was a true threat here that Judge Lamise took seriously and was beyond a political statement or a statement made in jest. And then as to the element of the substantial likelihood of committing similar acts, Dr. Beasley testified that Mr. Donahoe continues to have difficulties with outbursts on the ward, and that because of his apparent inability to seek his own treatment for his mental illness in the community, that he would be at substantial likelihood of committing similar acts if he were released. And then as to grave disability, I'll concede that there's no evidence in the record that Mr. Donahoe was somehow unable to meet his basic health and safety needs on his own. There's been no testimony that he could not get food or housing or clothing or things like that, the basic necessities of life. But the testimony is here that he would be at high risk of coming to the attention of law enforcement or being involuntarily detained because he's unable to make a rational choice about his own need for psychiatric treatment or to direct his own psychiatric care. And then finally, as to the less restrictive alternative, Dr. Beasley testified that if Mr. Donahoe were released to a less restrictive alternative right now, that he would likely not be medication compliant and that he would have a lot of the same issues that we're worried about if he were released unconditionally, if he were released even under court order to a less restrictive alternative. So I'd ask the court to enter the orders as requested.
On behalf of Mr. Donahoe, we're asking the court to dismiss the petition today. As to the underlying acts constituting a felony, I don't disagree with the state's interpretation of the relevant case law, but I guess what I'll point out is the case that I provided to the court and to counsel, State versus Brown, is a case from 2007 from Division 2 here in Pierce County. State v. Brown talks about what constitutes a true threat, and that a true threat has to be present in order to, again, not infringe on First Amendment rights of an individual. And so in talking about what a true threat is, the court said that the relevant constitutional question is whether there's sufficient evidence that a reasonable person in the defendant's position would foresee that his comments would be interpreted as a serious statement of intent to inflict serious bodily injury or death. And so I'll come back to that in a moment, but first of all, I don't think that there was clear, cogent, and convincing evidence that the letter that Judge Price received was authored by Mr. Donahoe. The detective who testified specifically testified that he did not know who wrote either the letter that was sent to Judge Price or addressed to Judge Price, and that he specifically didn't know who had written on the papers that were delivered to him from a cell in the Thurston County Jail. The letter had a return address with a different name of a different inmate in the Thurston County Jail. The detective testified that he had spoken with that person, and there's no testimony about any type of investigation that was conducted as to that person and whether that person wrote the letter. The detective himself just assumed that the handwriting wasn't similar and disregarded a further investigation on the part of Mr. Hughes. The state has the burden here. We don't have any burden, and there's been no testimony that would establish that other people didn't have access to Mr. Donahoe's cell, if that's where in fact the crumpled papers came from. There's no actual testimony that anyone saw him writing on those pieces of paper. The state cites that there was a similar cause number to a competency evaluation. I don't believe that those were facts and evidence here today. The state had Dr. Beasley read from a competency evaluation that was not admitted into evidence, that wasn't testified to. Additionally, the document that references cause numbers as Exhibit 3, in my recollection of the court's ruling, was that Exhibit 3 was being admitted only to allow the detective to offer an opinion about comparing handwriting. It wasn't being admitted for the truth of what was contained in the document. So I don't think that there's enough evidence to show that it was Mr. Donahoe who wrote the letter. If the court disagrees and we get to the point where we're discussing as to whether it's a threat or not, again, Division 2's indicated that the relevant constitutional question is, I'm just going to read it again, whether there's sufficient evidence that a reasonable person in the defendant's position would foresee that his comments would be interpreted as a serious statement. One, this is a request to harm other people, asking for permission to do so. The detective noted that the letter specifically stated that I'm not violent. That was read into the record. Additionally, Mr. Donahoe, per the detective's testimony, was in custody at the time that this letter was sent from whoever it was sent from. The motion is titled "To Kill in 24 Hours." Mr. Donahoe was in custody during that time, and so if we're talking about whether a reasonable person in his position would foresee that that could be interpreted as a serious statement of intent to inflict bodily injury, I just don't think that that's plausible. In State v. Brown, Mr. Bolling's correct that the court looked at statements that they considered past statements on the part of the individual, that he had thoughts about harming a judge. And I guess I would argue that I would say that these are past statements, because by the time that Judge Lanise, who testified, even became aware of the document that was sent, again, it was a motion to kill in 24 hours, would constitute a past threat. Additionally, the court in Division 2 specifically noted that one of the factors they took into consideration was that there was no specific plan outlined to harm the judge in that case. And here again, I specifically asked on cross-examination to the detective whether there was any type of specifics or plan about the intent to harm any of the individuals listed in that letter, and he indicated there was not. And so I don't think that this would constitute a true threat pursuant to the relevant case law. And then to move on, like the state did, to the second portion of the statute, the threat has to be directed to a judge because of a ruling or decision. Mr. Donahoe, in response to the state's cross-examination, specifically said that it wasn't until 15 minutes ago that he even knew that Judge Lanise had dismissed the motion that he had filed, that had just come to his attention. So I don't know how the state has proved that even if the letter was sent by Mr. Donahoe, and if the court believes it was a threat, that it was because of the judge's ruling or decision in that case. I think the evidence presented today is to the contrary. And so I don't think that the burden's been met as to establishing acts constituting intimidating a judge. In this case, I'm certainly not commenting on the seriousness of which the judge took the letter that he received and the actions he took, but the court has to look at the burden of proof in the statute, and I think given the case law, I don't think that this is a true threat that was directed to a judge. I don't think there's enough evidence to establish that Mr. Donahoe's the person who sent the letter to begin with. In terms of grave disability, I'll just move to prong B, since the state's indicating they're not moving under prong A at this time. Dr. Beasley testified about a lot of symptoms. The only specific example when asked was that Mr. Donahoe will come back to the same topic over and over, and that he continues to say that he's held here illegally and will sue everyone in the hospital. Even if that were to be true, that's not sufficient evidence by clear, cogent, convincing evidence that he has no cognitive or volitional control. There's testimony that 6 years ago he was, or in 2013, he was here for some type of competency case. 7105 has a specific portion that indicates that competency has no bearing as to whether someone is gravely disabled or meets criteria for grave disability or not. The only other testimony was that there was maybe a 72-hour detention. In 2018, Dr. Beasley indicated that she did not specifically review any of that documentation, that she obtained that from another report that she had reviewed. And so I don't think that there is sufficient proof that there's a repeated and escalating loss of cognitive and volitional control. So we're asking the court to dismiss the petition today.
Just a brief follow-up, Your Honor. First, I'll note, Your Honor, one of the difficulties with these cases is that the court is not supposed to take into account the intent of the actor. And so when we look at a standard like this that's been outlined in Brown, the constitutional standard is whether there is sufficient evidence that a reasonable person in the defendant's position, or here the respondent's position, would foresee that his comments would be interpreted as a serious statement of intent to inflict serious bodily injury or death. And in a case like this, where we're dealing with issues of mental illness and some linkage between the mental illness and the alleged acts, it's difficult to parse that. In any event, it's an objective standard, and under that objective standard, would a person standing outside of this look at what Mr. Donahoe wrote in that letter and say that this is a threat towards a judge? Is this a threat to kill a judge or their family in this letter? And I think the answer to that is yes. And then as to the evidence linking Mr. Donahoe to the actual letter that was sent, the court is allowed to make reasonable inferences from the evidence. It doesn't need to have everything proven to crystal clarity. That's even beyond a reasonable doubt standard. It just needs to be highly probable that Mr. Donahoe committed the alleged acts here. So I'd ask the court to enter the orders as requested.
So give me just 1 minute, all right? This clearly is not the easiest case I have seen in terms of weighing the evidence and what's in front of me and looking at the statute. And I did spend time a minute ago looking at the statute, the case law, but I also looked last night at the statute before I knew I was going to be hearing this case. The difficulty here is, so I'm going to go through the factors in terms on the felony, in terms of whether or not, and I will look, it is clear, convincing, and cogent evidence, so it's not beyond a reasonable doubt. I think I can find that it is the respondent who wrote this particular letter based on the information that I have in front of me. While some of the tangential ties were not perfect with regard to testimony from the detective, there's enough similarities between this particular letter and what came out of the cell that was witnessed to be this respondent's cell, where the officers went into this cell and came out with these documents that were crumpled up, per se, along with basic comparisons that almost anyone looking at these two letters or pieces of paper could make in terms of being more likely than not the same person who prepared them, along with the references to the various cause numbers. I think it is highly probable that he wrote the letter. I would also note that he was able to fill in the blanks in unique detail on his own volition in this courtroom when the detective had problems reading portions of the letter. So that would say that it is more likely than not that this defendant wrote the letter. It was directed, in essence, to the judicial officers in this case because it was sent to the court, which is generally where people send things. Sometimes it shows up at judicial officers' mailboxes, but oftentimes it just shows up at court or court administration, or a generic threat is made. So I think it was communicated. I think that the tie has been met, that it was as a result of at least one of these particular judges' rulings. We have a connection that he was involved in several cases. I understand that he states, that the respondent did state that he didn't know about the one dismissal, but there was also the arraignment and other issues that the judge testified to that he had contact with the respondent.
That's why he lied.
Okay. The prong that I have more difficulty with
Is for you to stop being a criminal.
Mr. Donna.
You're not helping your case, Mr.
I am.
Donahue, so I
You're
suggest-
condemning yourself. You have no jurisdiction in this matter.
Count to three, either you are quiet or they're going to exit you out of here. So, all right, 1, we're done. All right. So, the statute connotates an immediate threat or to take immediate action.
May I interject, Your Honor? The statute does refer to the definitions section.
No, I have it.
Oh, I'm sorry.
I've got the
I apologize.
definitions.
I apologize.
That's okay. So this is the prong that I have a little bit more trouble with. But the fact that he was being confined at the time does not mean he would not carry out on that threat when he is released. And initially when I looked at it, I looked at okay, he's kind of offering due process, but then later in the letter he basically says he's taking back due process, and then he has a right to carry it out without due process, and he goes on to list the judge's family members. And although he says he's not violent, he says he can be if he's provoked.
You just tried to poison me 3 days ago, Judge.
So-
I have a right to fight back and say, you're going to get disbarred. I'm going to file case law to have you disbarred.
Okay, I'm going to have you...
I have a right to defend myself.
All right.
Get up. Take a look that way, no. He won't.
I think a reasonable person, or from an objective standard, should understand that, and we're not looking at intent, but it is a reasonable person standard, though, because we don't look at intent like a reasonable person. So, I mean, I think the language in itself would create a reasonable basis for fear with regard to the judge. But as difficult as this is going to probably be for the state, I can't, because it's a motion, it looks like he's asking the court to issue a ruling on the matter. That is his plan. His plan is to get permission for this so-called threat to be carried out. And I don't know that anyone can tell me I can't consider the comments made by this particular respondent throughout this hearing. And all he keeps saying is he's filing suits against everyone involved in this. He's going to sue, he's going to disbar, he's going to ask that someone be executed. But he's doing it through judicial channels. He doesn't have a plan to run out of jail and go execute it on his own. So, although I think almost every one of the other parts of the statute is met, I can't see that he had an actual plan where he intended to go create harm or hire someone to go create harm on the judge. I understand why the judge is fearful. I understand that. But based on what I'm reading and what I'm seeing, so I'm going to read the statute one more time before I finish my sentence.
Well, Your Honor, may I add something to my argument?
And I'm going to object. We're done with closing arguments and the court's making its ruling.
I just have a clarification on the law, Your Honor.
He can clarify the law if you find that he misclarifies on the law. You can clarification on the law is not going to be terrible. I'm kind of clarifying it on my own up here, to be honest, and I apologize, but this isn't the easiest case in the world, and I will go on record on saying that. And I'm torn on this one prong, so I'm up here reading it because I am back and forth on it, and I don't have any problem telling both counsel that I'm back and forth on it. I'm pretty clear on all the prongs that I've already given you. This court has concerns as to, and I think what I'd like to know is if I'm entitled to look at this person's JIS. I believe that I am in a case like this, and I've looked at his JIS, and no one has mentioned his JIS. But his JIS would lead this court to believe, so this is where I'm going with my ruling. The JIS would lead this court to believe that he's capable of carrying out this threat if he were not confined, because his JIS shows multiple times where he doesn't abide by court orders. So if a court said we're not going to give you your due process and tell you that you cannot kill this particular judge, the same as he's been ordered not to contact certain victims, the same as he's been ordered not to do other violent behavior, this court is not convinced that he would not act on it. And I do believe it's a legitimate threat. The question is how he intended to carry it out. I think he is capable of carrying it out if the court did not grant his motion, which we know it's a false motion, but let's just hypothetically say he filed it. If the court did not grant that motion, this court is not convinced, and I actually am more convinced that he may take actions given his state of being and his what has been testified to as lack of volitional control and his prior history on JIS, that he wouldn't abide by the court order itself.
So I had 2 points on the law that I wanted to bring up, Your Honor, and if defense counsel disagrees, I'm more than willing to hear from her. The first is from State v. Brown, which defense counsel gave a copy to me and to the court. It says in there at paragraph 10, whether he intended to carry out the threat is irrelevant, as our Supreme Court has said that in order to show a true threat for First Amendment purposes, the state need not prove the defendant actually intended to carry out the threat. And then additionally, under RCW 7105, the state is not required to prove intent.
Correct.
In order to prove the acts constituting a felony. Those are the only clarifications I wanted to make.
And I guess just for my record, his JIS and any testimony about how that would affect the elements of the underlying felony are not in evidence, and so I would be objecting to the court considering those. I further don't think that those actually go to the elements of what the state had to prove today in terms of the acts constituting the felony. I would agree with the court that I think I argued this, that it is a request to do something. It's not, there's no statement that says, I am going to do this. It's continued in that statement, and the court, I think, is finding that there's clear, cogent, convincing evidence that that it's highly probable Mr. Donahoe wrote the letter. There's nothing in the letter that says, I'm going to kill Judge Lanise. It's entitled a motion to kill, and I would agree with the court, as the court has noted, that Mr. Donahoe seems to go through the legal channels a lot, and I think that, again, I would agree with the court's reasoning as to that, but additionally, I think that we have to look at State v. Brown, and that talks about when the state has actually established sufficient evidence for the court to make a finding. And so if we're looking at whether there's sufficient evidence here, we're told that the relevant constitutional question is whether a person in my client's position would foresee that his comments would be interpreted as a serious statement to inflict injury or death. And again, he's in custody at the time the letter sent. It's entitled a request to kill or a motion to kill within 24 hours. After the fact, the judge receives a letter and that time has passed. So it's a past threat. The court indicated in State v. Brown that that's not sufficient to constitute a true threat. And so I think that the court should rely on that case and agree that this didn't actually constitute a true threat in the sense of that as interpreted by Division 2.
So I'm going to backtrack a little bit on the JAS, although I did review it. I do have to clarify that some of those things on the JAS were not actual convictions. So some of that I can't, for this purpose, consider some of them because he was declared incompetent and we haven't run through the litany of that. So I will take that back. I do believe that even if it's not admitted into evidence, that I have a duty to look at it. But I will take that piece back because that is something that this court just realized on their own. I do believe that it is not relevant that he may or may not have intended to carry it out. I do think that the standard is, would a reasonable person think that it's a legitimate threat? The fact that it's phrased as a motion, that doesn't hold up this court as much. And the person receiving the threat may or may not. Even if he never intended to carry it out, it's still a threat. It's close in time to when some of these things were issued. And it certainly, from an objective, which I can't believe we're arguing an objective person standard, but a reasonable person standard, but we are, it would connotate a threat. So I am finding that the state has met its burden after that long dialogue.
And right. For clarification, how I'm interpreting the case law is that it's a reasonable person and the defendant choose not the person who receives the threat. So is the court indicating that...
I think that both persons in this case would deem this to be a threat. If you send a letter, I'm not allowed to consider his mental state when I'm considering this because I can't consider intent. So I'm taking that to believe I can't consider his quote-unquote mental state either way. And if any person writing this letter, sending it to the actual court where the person he's threatening is going to receive it, it should be conceived that the person receiving it would take it as a threat, especially when the person addendums it and says he's going to do it with or without due process and then proceeds to end family members, wife and kids, which he would have no way of knowing. Would be a little scary to think that this person... So if by listing wife and kids, I think that adds to what he should think would be deemed as a threat. With regard to the grave disability prong number 2, we have testimony that although he can see to his basic needs, he can get food, he can keep himself safe within a confined area. I think he would be at risk given his tendency and lack of volitional and cognitive control to stay safe in the community. He's likely to end up in altercations. But I also believe it's more likely than not that he would engage in behaviors similar to the behaviors that got him here in the first place.
And on the LRA, Your Honor?
I do not believe he is ready for a least restrictive alternative at this point. There's no evidence that he would do what he has been ordered to do or take the medications that he should be taking outside of confinement. He's made it very clear he doesn't think he needs the help. Confinement's the wrong word, but hospitalization.
All right.
Thank you, Your Honor.
Thanks.
And do we need to put a continuance on the record for the med hearing, or is the court setting that over administratively?
And it should, I think you should do a motion since it's your request.